Hello, everyone. Glad you could make it. I know this is such an exciting topic, so we'll just try to keep all that energy down on the issue of wage and hour. I know it's something that's bothering you at the offices. It is an important issue that needs to be discussed. Make sure you're doing it right. We're seeing a lot of lawsuits coming out on wage and hour, so they thought this would be an important topic to address with everyone. Certainly is a refresher for some of you who have been operating businesses for a while, maybe doing certain things right, maybe a few things wrong. And it's also a very sort of complicated area of law. A lot of you have moved to using employment companies to work with and handle the payroll and the hours and answering your questions like that, which is great. Some of you are trying to do it on your own. We're going to walk through a lot of topics today. Hopefully you'll feel a bit more comfortable about some of these issues when we're done. So let's start off. All right, so I think the number one issue when it comes to, especially in self-storage, goes to the question of exempt versus non-exempt employees. And people get in a lot of trouble with this because you're hiring folks to manage your properties, your very valuable properties, millions of dollars of real estate, and you are putting them in the office to manage those properties, and you are paying them relatively well to do so with potentially an assumption that that puts them at a higher level and taking them out of a hourly employment scenario, meaning they're paid on an hourly basis and entitled to overtime for over 40 hours worked per week. And California is a little different. We'll talk about that. More than 8 hours a day in California, entitling them to overtime. So you're paying folks and you're making this assumption that because of the amount that you're paying them, they would be entitled to this exemption, alleviating the obligation of overtime. And it's not true. And it's somehow hard to digest the fact that folks that are taking on these responsibilities at the facilities, and some of you may be managers in the audience, they do not fall into any classification to exempt them and putting them into an exempt status because of what they do at the office, and we'll go through that. Now, it's more than just what they do at the office. It also is based upon what they make, and what we'll go through in just a minute is these issues concerning what are the requirements to become exempt and to fall out of the non-exempt classification. And let me say again, non-exempt would be folks entitled to time and a half for over 40 hours worked. Exempt, therefore, not entitled to an overtime compensation for that process. And to make the determination between exempt and non-exempt is based upon certain test criteria. So let's start out just a little background. In terms of what a minimum wage is, there's a federal minimum wage, and then the states themselves can establish a minimum wage as long as that it's higher than the federal minimum wage. So let's start with the federal minimum wage. I'll give you a quiz. The federal minimum wage is, I'll do it like an auctioneer. I hear what? Seven what? Seven, I hear seven and a quarter. Anyone want to go higher than that? It was a good try. No, he's right. $7.25 is the federal minimum wage. So and it'd be very surprising to hear that any of you would potentially be paying your site managers $7.25 an hour for the 40 hours worked. I mean, that's a significant $15,000, $16,000 a year compensation. So, and of course, that's a minimum wage that applies to different classifications of job employment. But what we see in many states, and many of you have heard about this, especially in states like New York and California, why I bring these examples out, is you're seeing a higher hourly minimum wage in those states as long as it's above the federal. So if you're in another state like New York or California, the federal minimum wage is preempted by the state wage, which is higher. Those folks are entitled. We're looking at New York this year, and New York's going to continue to go up, as is California. New York is working towards an annual increase until it gets to about $15 an hour for minimum wage in New York. But it works out that those folks, $15 an hour minimum wage, working over 40 hours a week are entitled to time and a half in those states. So again, you have to look at the federal and then the state minimum wage to determine what folks are entitled to as again, a non-exempt employee. And then we'll go to the issue of the salary test and the job scope responsibilities or the job duties test to determine whether they could be exempt employees. And I'll tell you right now, it is not something that your self-storage site managers would be exempt employees, no matter how much of a job they have because of the issues regarding the classifications. So the current minimum salary to be exempt is $455 a week or $23,660 a year. So that is a minimum to even be considered for exempt status. This is the salary test. Now, some of you may have recalled back, it's already a year ago, as President Obama was leaving office, he tried to have the Department of Labor increase that minimum to determine exempt status to $47,000. But the Trump administration stopped that, leaving the salary test for a determination of exempt status of a minimum of $23,000. So you can't even talk about an employee that would potentially be exempt, again, not entitled to overtime for over 40 hours worked, exempt as long as they made that much money. And then above that is the job duties test. But I wanted to point out again, states can increase what the federal government has determined as part of that salary test. So in New York, you have a $50,700 minimum before anyone could potentially be exempt. So if they're making $45,000 a year in New York, they automatically will end up being in the non-exempt category because they're not making enough under the minimum salary test. Okay, I think you can follow. In California, $45,000. And these continue to increase as well in these states. And you can find this online very simply. Go to your state, put in minimum wage classification test, and it will tell you what the amount is and what it's increasing each year. But again, you can't even fall into the exempt status as long as you're making less than that minimum. And that's a relatively low minimum, obviously, at this point. All right, and then what's really important, especially in self-storage, is then the duties test. And the duties test would be that the primary duty is management, not necessarily of the facility, but of others in terms of this classification to be, whether it's professional, executive, or administrative. And you may have seen that those are types of exemptions or duties classification to allow someone to be exempt. But even within that, they must direct the work of at least 2 full-time employees to be considered exempt, part of that scope. It must be able to hire and fire, have independent judgment with respect to the operation of that business. So think about the site managers that you have at your facility, and primarily we're talking about this. We can talk about when you move to area managers or district managers or field managers that you might have that then do oversee 2 or more people full-time, then you're dealing with a different classification. Right now I'm just talking about the site manager. So the site manager, likely, you do not have hiring and firing responsibility for those folks. They are not managing 2 or other people full-time. They may have a relief manager, but that relief manager sometimes is part-time. So it doesn't fall into the requirements for the duties test for a site manager to be an exempt employee. So again, we've gone through this in a number of cases, a number of courts, all in the context of self-storage, have found that self-storage site managers are non-exempt, again, entitled to overtime, and do not fall into the exemptions or classification exemptions, whether in salary or duties, to create that protection for you as an employer. All right, so that's really important it may be a wake-up call for you. And I know that the next question that comes to your mind when it comes to this question of, well, now my folks are all non-exempt employees, can I pay them a salary, even though they're supposed to be paid hourly with entitlement for overtime? Can I still pay them a salary? And the answer is yes, and we'll talk about how to do that in just a minute. All right. Why we talk about this is because, as I mentioned, a lot of what we do in defending employers is back wage claims. You fire an employee, and it's usually this case, and some of you may have been through this. Your employees will bring these actions for failure to have been compensated for the period of time that they worked, likely after you fire them. They're not happy. They think that they are entitled to more money. They go to a lawyer, they go to the Department of Labor, complain. Many of you maybe have faced audits by the Department of Labor with regard to how you're paying your employees, because there's a large opportunity for compensation for employees who feel that they haven't been receiving their back wages, that you've shortchanged them because of overtime that they should have gotten when they're at the site. Because there's double damages, recovery of attorney's fees, opportunity for class actions to the extent that a lawyer finds not only one unhappy employee that you've had, but 2 or 3, and it becomes a problem. And the danger is, and this is really where you get yourselves in trouble, the phrase like no good deed goes unpunished. You've tried to be fair to your employees. You think you're doing the things right. None of this is intentional, but afterwards when they're terminated and they go seek legal advice, the lawyer that's familiar with employment is going to say, did they do this? Do they have the records for that? And when their answer is no, but they were good bosses, but they fired me, it creates that open door for the opportunity for the lawsuits. So that's why these claims are so prevalent, both in self-storage and other industries. All right, so avoiding liability. Number one issue is having employment agreements with your employees that spell out the fact that they are non-exempt employees, have a standard wage for hourly work, an overtime wage for the overtime hours, and it goes through the explanation of who they are, not only just with regard to salary and compensation, but other things. Do you provide vacation? Do you provide health care? Do you provide a bonus program? Whatever it may be, it's in an agreement that's a written document. It avoids all of those issues that many of you may have faced, which is, well, you promised me that. No, I didn't. Well, where's the writing? And that's where, even in the context of self-storage, you would want something with your employees that's in writing to help you and them with respect to the clarity of what their responsibilities are. Agreement should provide that permission must be given before additional hours worked. This is really where we get into the question of, now you're dealing with a non-exempt employee, your site manager primarily, that would be entitled to overtime for more than 40 hours worked. And I don't know really of any self-storage facility that's just open 40 hours a week. You're working, as long as you're working into Saturdays, sometimes Sunday hours, you're dealing with a longer work week than the 40 hours, which means you have to anticipate a certain number of overtime as part of the compensation for that site manager. Now, you may have a series of different managers working out a schedule, so maybe they're not working more than 40 hours a week, but if you have one or two employees, it's likely they're working more than 40 hours a week. You can provide in that employment agreement that they must get, if they're going to work over the hours that you've anticipated for them and contracted with them, they must get permission for those hours. Now, the Department of Labor would tell you that if they work those overtime hours, even without permission, they're entitled to be paid for those overtime hours. Tenant came in at 3 in the morning, banging on the door. I got to get to my stuff. I had to put clothes on. I had to go downstairs. I had to see what the ruckus was. I let them into their unit. That's more hours than they anticipated. They are entitled to be paid for those hours. They need to report that, entitled to be paid for it. Things like that happen in self-storage, whether it's a resident manager or whatever. Things happen at self-storage. They call about a police are coming to your facility. The manager has to go from their house to the facility. Things happen in an overtime context. They're entitled to be paid for that. What you can do in your employment agreement, though, is if you are getting these overtime claims by your managers, hey, I had to do this, I had to do this, I had to do this, without permission, because of the contract says that you have to get permission, you have to pay them for the hours, but you could say, you know what, this isn't right. I'm going to terminate you, or it's subject to termination because you're not following the rules and you're taking advantage. So even though you have to pay them for the hours, you have the right, because of the breach of the employment agreement, to terminate if you so choose. What it means ultimately is the fact that you could create a scenario where you can control the risk of just runaway overtime hours by your managers. Agreement should provide that employees cannot work off the clock, which is a claim we get a lot, which is, well, they didn't want me to bill the overtime, but they expected me to do this. They expected me to come in a half an hour early to do a lock check before I signed in at the office. Well, that's compensable time for a site manager. And this is where any claim by you that just says, go ahead and do it, but just keep it off the clock, is subject to a back wage claim because they're entitled to every hour that they work on the site. Now, we'll talk about how you confirm some of these hours in just a minute. Agreement should provide that employees must log all their worked hours on a weekly basis. One of the things that's a reality check for you guys, and I know how hard it is you've got these facilities, you're hiring really qualified site managers. It's a very professional relationship now. We've moved a lot over the last 10, 15 years to professional retail managers. To hire someone and then say, you know what, you got to clock in, you got to clock out. You got to clock in, you got to clock out. Sorry, I got to keep track of your hours. I think you'd agree with me, in many instances this feels demeaning for you to say this to your employee, and many of you are reticent to do that, and therefore your position is, come in, come out, just tell me at the end of the week how many hours you've charged, or just make sure we're on track, or maybe at the end of the month. Okay, very dangerous to do. There has to be a mechanism in place. There's software out there where someone can turn on their computer and check in, other things without the old time clock. So there's ways to do it. That protects you because you will find it is your burden, the employer's burden, to prove the number of hours that the employee worked. It's not the employee's responsibility. So if you do not have a record-keeping program and the employee says, I worked 100 hours last week, and they sue you for the 100 hours, and you have no mechanism of keeping track of your employee's hours, the employee gets the benefit of that lack of information in the courts. The courts defer to the employees over the employers, putting the burden on you to make sure you have systems in place to clock the hours of your employees. Now, their failure to do the required record keeping themselves, clocking in and clocking out, again under the employment agreement, could be subject to your right to terminate. Hey, you're not following the rules. You got to clock in, clock out. Sorry, even if it's biometrically or on the computer. If you don't do that, then it's subject to termination. So it imposes the obligation on the employee to do the checking in and checking out. All right, it's the employer's duty to track the hours. If the employee brings a claim, you must be able to demonstrate your hours, and technology makes it easy. That's the responsibility that you have with regard to the hours. Resident managers. I get this question a lot with regard to resident managers, different from retail site managers, because they're living on site. So, the argument is, and some of you have seen this, some of you may have suffered through this, I work 24 hours a day because I live there. I'm looking out the window to see if the site's okay. I'm here at a moment's notice to deal with something that happens at the facility because I live at the facility. Now, I don't even want to begin to calculate what 24 hours a day, 7 days a week for a site manager would be, but I would assume none of you could afford to keep managers that are charging that much to run your facilities. The law says you can have people living on site, and the contract that they would agree to would agree that they are not to work the hours other than agreed to between the parties, and they have the right to live their life in their apartment. They can have friends over, the dinner parties, they can watch TV, whatever they're going to do in their apartment because they're allowed to live there, and that's not working hours. But again, it goes back to the original issue about having in a contract that clarifies that. There's a clear federal law that provides that if the language is in your employment agreement, notifying the employee that they have the right to their other life activities, even if they're living on the site, meets the requirement that you've given them the notice and that they would know that they don't have to work 24 hours a day, to avoid any misunderstanding that, hey, if I live here, I have to work 24 hours a day. Now, understanding that if they're living there, it may create scenarios more often than not where you get the tenant knocking at the door at 3 in the morning, something smells in the facility that they have to investigate, whatever may happen. You guys know this, you've lived through it. So things that happen. So they're entitled to overtime. Remember, just notify you about the overtime of things that have happened. It's not that they are entitled to 24 hours a day, 7 days a week. So, but again, the burden's on you as the employer to clarify what hours the employee is supposed to work and not work. All right, let's move a little bit to the other issues other than just the wage and the exempt and non-exempt, although I want to make sure that's, again, clear with you. I think the solution to any risk that you have as an employer in a wage and hour situation is an employment agreement with your employee, clarifying the hours they're supposed to work, even including the overtime that they're entitled to, and other terms with regard to overtime rights. I forgot to mention this. Yes, you can create a salary for that employee in that employment agreement, but all it is the following. Let's say you pay them $10 an hour straight time wage, okay? $10 times 40 hours, I can do the math, bear with me, just checking to see if you're, $400, right? Okay, so that's $400 salary. But you know what, they work more than 40 hours a week, they work 45 hours. So those 5 hours that they're contracted to work, they get paid, quiz, how much? $15 an hour for 5 hours. So this I can't do in my head. 15 times 5, whatever that number is on top of the 400, and that's their weekly salary. So you can create a payroll system where they get the weekly salary based upon the calculated straight time and overtime dollars that they get. Now, again, if they have overtime that week, you'd have to issue a separate check to cover the overtime, maybe, or bi-weekly or bi-monthly, if so, I should say that. that you would issue the overtime recovery for anything that they declared to you that they worked overtime. But that's one way you can solve the salary issue. So you're paying them a salary, but it's really a non-exempt hourly calculation. All right, employee breaks, are they required? Now this may be a surprise to some of you, that at least under federal law, an employee isn't entitled to a break during the hours they work at the company. Not entitled. It's pretty mean. Everybody needs a break. You know, are they entitled to a break? No. No. State law is different. You got certain states, again, looking at states like California, New York, that require an employer, and this is going to depend on the states where your facilities are located, that you give your employees typically that 15 minutes in the morning, 15 minutes in the afternoon, and the lunch break. Okay? But it's going to be dependent upon your state, and certainly if you're a multi-state operator, you're dealing with the requirement of dealing with potentially different rules, different employment agreement obligations in the different states that you're working in. Now, breaks less than 20 minutes, this is under federal law and followed in state law, under 20 minutes are compensable. So if an employee leaves and uses the restroom, okay, it's not like you're going to dock pay if they're in the restroom, or if they go, someone asked me about take a cigarette break. If it's under 20 minutes, or a coffee break, if it's under 20 minutes, they've left their station, left the facility for less than 20 minutes, it's still compensable as a non-exempt employee being paid hourly. But if they take a break longer than 30 minutes and longer, you're allowed to turn off the clock. And that's the instruction you give them if they leave the office or leave their work, maybe they go back up to their apartment for more than 30 minutes, clock in, clock out, or it's depending upon how they manage that time, you don't have to pay them for that time. Now, some of you would already have calculated those hours as part of we just talked about your salary calculation. And some of you then may say, you know what, I'm not going to recalculate the fact because they took a 45-minute break one day because they had to deal with something with their family. But if you did not, if the break was less than 20 minutes and you try to deduct that time, you'd be in violation of the federal and state laws. You have a question? A break of 25 minutes. Break of 25 minutes is, because it's non-compensable time. It's really more than 20 minutes. It's more than 20 minutes. The issue here on the difference of the 20 and 30 minutes is just that ambiguity period that comes up a lot. So what happens is you have a situation where clearly it's more than 30 minutes, you're easy. If it's somewhere between 20 and 30 minutes, it creates a level of ambiguity. So I'd just be careful about that with regard to giving breaks, yeah. Well, it's a great question. So the question is, can they leave during that less than 20-minute break? And the answer is, yes, they can. Now, you may not want them to leave the facility. I mean, a lot of these laws go to the extent that someone is, maybe they're going in the back to have a cigarette or going in the break room to have a cup of coffee, whatever it may be, that they're still nearby. But it's not clear. I mean, if they could get where they're going and get back into 20 minutes, it's still compensable time. They'd have to shut the office down, and you have to recognize this. Now, again, some states don't even allow this, in terms of compensation. My sense would be you would work through a schedule with your employee as to when they would be taking breaks, so you know as the employer that they're not there. And the breaks are very important in self-storage because you don't know when customers are going to come, when the phone's going to ring. So you have to have a plan in place. Separate from that, though, is the problem that you have to realize as an employer, you have to pay them for those breaks unless they're over 30 minutes. Yeah. He said that she clocks in, clocks out. They'll pay her for those 10 minutes because they have to.
Are they supposed to pay her for 15, even though they say they only pay for 10? I mean, if she comes back in 15 minutes, are they required to pay her for the whole 15?
Well, under federal law, no. State specific, it may depend. I mean, that's why you're going to have to look at your particular state law with regard to that. I would tell your wife if they're not paying for those 5 extra minutes of break, she's got a problem. I mean, that's this is just a reality check of sort of, how people work, that people need breaks. All right, so this might be something you didn't know before with regard to the obligation of no breaks as compared to your state checking to see what you can do. This is where you get in trouble to the extent that you may not have a proper break policy for your state, could result in a back wage claim. Next one, vacations or sick leave. Many of you give these anyway as part of the benefit package to your employees. Federal law would say not required. State law may in fact provide it. Now I will tell you that you find certain sick leave obligations, again, in states like California will have a sick leave policy, even a longer family leave policy in California that's different from the federal Federal Leave Act program, Medical Leave Act program, but it's all going to be state specific as to what your requirements are, but the federal law would say no. But if you're a multi-state operator, you may have a different employment agreement dealing with different benefits. Now, it may not matter to you because you may provide those, the sick leave policies or vacation plans as part of your general plan for all of your employees across the board. If you're doing that, you're going to at least want to make sure that you're meeting the minimum requirements of at least one of the states that you're operating in. You may have, one state that you have, the 1 week, and then that meets all the other requirements of the other states that you may be operating in. All right. Lunch breaks. This one's maybe new to you as well. Federal law does not require that your employee has lunch breaks. But again, different states will have different rules with regard to the obligation of giving a lunch break. Now, a question came up, if you give them an hour for lunch, half an hour, well, yeah, because that half an hour becomes that compensable question. Let's say an hour for lunch. Okay. Can they leave during that hour for lunch? Close the office, leave, and therefore non-compensable time? The answer is yes. What if you say to them, you're allowed to have lunch, but you have to stay in the office? You have to pay them. So again, I know this is happening at some of your facilities where you do not want your employee leaving, putting that little sign on the door that says, I'll be back in an hour, because you potentially lose customers during that time where they may be on their lunch break. Where in fact, other customers who are getting a lunch break from their businesses are coming over to your facility to quickly sign that rental agreement, and you're closed. So you say, you know what, you can have lunch, but I want you at the facility. Well, okay. Under federal law, you'd be able to say that. Now, some state laws, again, I can't do them all, there's 50 states, would require you to give the break. But in the states that don't require it, if you, again, we're talking about company policy versus the fact that now you're dealing with a wage and hour issue. If you give them the lunch break but require them to stay at the facility, it's going to be compensable time. So it's not, it's not an hour that, if they're required to stay there, that you don't have to pay them for. It gets tricky. You may want to calculate those hours and work out a work schedule with your employee in advance to make sure that you don't get into the trouble with the wage issues, and work out something that works for your employees on a regular basis at their facilities. Yeah. Okay, so the question is, if you give them an hour and you give them the option of staying or going, if they stay, if their option is to stay, they're free to leave. That's non-compensable time. Because they could stay in the office, they could read a book, they could do whatever they want. That's not compensable time. They would have to, under your system, they'd have to clock out, then clock back in. I say that again, not with the timestamp as much, but computer log in, log out for lunch breaks. You would not have to pay them for that time if it's their option to leave. And in fact, many of them will find that they will take that chance to leave from the office. On call. This comes up a lot with respect to many of you who have a site and you pick a manager, or maybe even the manager, when they're closed, and you give them the red phone, the bat phone. If it rings and they got to be on call if something happens at the facility. And then the question becomes, well, if I'm on call, don't you have to pay me for having the phone to come in if something happens at the facility, because I'm available to go in? The question becomes, what does it mean to be on call? If they have the phone and something happens and they are expected to get to the facility within 15 minutes or be accessible to be at the facility within a particular period of time, it may in fact restrict their right, as the statute says, for that employee to have their own personal needs or desires met off the clock. So don't go there, needs and desires. I don't know what that means. But they're allowed to have their own life when they're not working. And if you put them in an on-call situation, which means that they, again, need to be, on-call means you need to be at the facility. Now, it doesn't mean, look, if you're going to take a phone call to answer a question from a tenant as part of the rollover from the call center, that's not being on call. They can take the call, they can answer it, they can return the call within a certain period of time. That's probably not an on-call situation. It is, however, though, when they get the call, it may be overtime. So it's not that they are on call and you have to pay them for having the phone, but if the phone call comes in, they can report to you, I had 3 calls last night, each taking about 30 minutes for me to help the tenant because we got called on from the call service, whatever. Therefore, I've got now an hour and a half of overtime because I worked. Here's my overtime request because I had those phone calls. That's fine. They're entitled to be paid for that work done after their hours worked. But holding the phone and being available and saying, hey, I held onto the phone for 8 hours last night. I put it in the bed next to me in case it rang. You guys don't get my sense of humor. It's all right. Yeah, but I'm really a good employee. I kept it right here. It doesn't matter. Because if they're able to do their other needs and desires, then it's not compensable on-call time. Now, you may set up a system where in fact you want your employees to be on call in case something happens to your facility. I really don't know. I mean, it's very infrequent that you get the emergency phone call at a self-storage facility. Some of you probably, I know you've had them, but it doesn't happen every night. If it happens every night, you've got a different problem, right? So you could agree to, if you give the manager the phone to be on call that night, that you will pay them as an on-call scenario, but it typically is not working out that way. But you do have to pay them for the hours that they work as a result of having access to the office during that time. Comp time. We do hear a lot of, you know what, if you stay late for me tomorrow night and get this done, these reports, and I got to do this, and I got to report it back up to the management company, or the owner wants this, just stay for me an extra few hours tonight, and I'll give you comp time. Okay. Well, when you're dealing with a non-exempt employee entitled to their minimum wage or higher plus overtime, there's no such thing as comp time. So if you get into a situation, it's almost like that off-the-clock time where you offer something in consideration. The laws are very clear. There's no such thing as comp time for non-exempt employees. Every time they work is a compensable time. Now, this is different with exempt employees. So exempt employees, we talked about a little earlier, may in fact be your field managers, your district managers, your area managers that manage more than 2 employees as part of their job responsibilities, meeting that duties test, and likely are being paid more than the salary minimum. Well, that's different. You can structure a comp time program with exempt employees. But where you get into trouble is treating your site managers and offering a comp time program for extra hours worked. If they go back to being unhappy with you after termination and seek an overtime back wage claim, those hours are going to be recoverable with double damages and attorney's fees. All right, if I didn't blow your mind for the last couple minutes, this one will really drive you crazy, which is the issue of bonuses for your employees. Again, we're dealing with bonuses for non-exempt hourly employees. If you pay a bonus that what I would call is a non-discretionary bonus, which is a bonus that's based on objective criteria like number of units rented this month, number of visits to prospective customers, number of phone calls that convert to leases, whatever is a very in terms of objective determination of meeting criteria in advance for which they are entitled to a bonus, those are called non-discretionary bonuses. You can't in the middle of their employment go, you know what, you did a great job this month, you met that quota of 5 extra leases, but you know what, I'm not going to give you a bonus this month. And employees, well, you give it to me every month for these number of rentals, you're required to give it to me because that's a non-discretionary bonus. That's set up in the program. If you have a non-discretionary bonus, catch this, this will drive you crazy, the money that they make in a non-discretionary bonus, again, non-exempt employees, needs to be added to calculate or convert their straight time wage. So if they make an extra $100 a week or bi-monthly, $100, let's say $200 for their non-discretionary hitting their targets, that $100 now needs to be calculated into their straight time wage. So before they were making $10 an hour under our earlier example, now if you add their bonuses in, they're making, you have to do the math, you know, the $100 or $200 divided under the number of hours they're worked. Now it's, let's say it's $10.30 is the recalculated straight time wage. But don't forget, they have that 5 hours of overtime. So instead of it being $15, now it's like $16 for the overtime. So non-discretionary bonuses have to be calculated into their wage. So they would potentially get not only the bonus, but a up revision to their weekly or bi-monthly payment. Now, some of you are dealing with this through your employment companies and payroll companies, and they understand that if there's a non-discretionary bonus that you provide to your employees, they will adjust that within the compensation or salary that you're paying your employees. But be careful, because you have to report those bonuses. They can't be paid straight time out as extra compensation. They fall into the calculation of the minimum straight time wage for that employee, which again impacts the overtime calculation. And all this comes to fruition when an employee comes back later and says, hey, we had these regular non-discretionary bonuses and my straight time and overtime wage was not adjusted as a result. So be careful about that. As compared to what I would call discretionary bonuses, which are bonuses that you provide at the end of the year or at the end of a particular quarter of the year based upon subjective criteria. You're doing a great job, here's a $500 bonus. Well, that discretionary, because you can give them $500, you can give them $100, you can give them nothing. It's discretionary. Does not calculate back into their straight time wages. So now if you want to go back under your employment agreements and rethink your bonuses because of the complication of the overtime impact rate from non-discretionary, you can do that and just give discretionary bonuses. But be careful, do not describe your discretionary bonuses based on their performance of objective criteria. It has to be based upon subjective determination of their performance. Be very careful of setting any milestones under what you would call a discretionary bonus, number of units rented, number of revenue per month, number of locks sold, takes away the whole issue of potential discretionary. If you create any bonus programs based upon objective criteria, remember that it has to be calculated and recalculated into an employee's base wage, straight time wage, and their overtime. Can make you a little crazy, I know, but that's a lot of you will deal with your payroll companies to address it. Yeah. So your question goes to a travel bonus that is $3,000 towards a trip if they make certain criteria year over year. Okay. Now clearly that's a taxable income because they're considered, that's a wage compensation. And then the question is, could that, because it's based upon objective criteria, I assume, based upon year after year, would that potentially be included then in their straight time wage and overtime? And I'm afraid the answer would be yes. I'm afraid the answer is yes based upon the way that the Department of Labor gives deference to employees with regard to their wage claims. So any bonus programs that you create that would be, again, arguably non-discretionary based upon objective criteria could come back into. So now, it could be resolved this way. If you have a very clear employment agreement dealing with straight time wage and overtime per week, then the adjustment for that $3,000 bonus may be less than a couple $100 in terms of that adjustment of what they're entitled to be paid based upon receiving that bonus. That would be the safest way to do it. Have an assumed wage impact as a result of that bonus. But good question. I've already came to the end. All right, so I wanted to, because I assumed that I drove you guys crazy with respect to questions, so go ahead.
Without gift cards or vouchers or pertaining to that, you pay for a $3,000 voucher for a trip, and then instead of the cash.
Sneaky, good, but no. Any compensation to, a non-exempt employee based upon a non-discretionary determination. Now, if you do this as a, Employee of the Year program, and you provide it, you could make an argument that it's that it's discretionary and therefore not part of the compensable program. But otherwise, it's a little tricky. Because I wanted a couple other topics I want to just mention it before we finish as well. Yeah, go ahead. He asked the question, you have a part-time non-exempt employee, if they work more than 20 hours, because they're part-time, does that entitle them to overtime? The answer is no. It's 40 hours or 8 hours a day in California entitling the overtime. So you could have a part-time person that works more than 8 hours a day would be entitled to overtime for their unit wage. Yeah. The question is whether California is the only state that I know of that has the overtime requirement over 8 hours a day. Is anyone in any state that knows differently than that? Okay, I'm only familiar with good old California. It tries to make things as easy as possible. Yeah. So the question is, if they're given the apartment and the apartment has a value of $500 a month market value, can you use that $500 and make sure I'm answering your question? That $500, can you use that to come up with to meet minimum wage requirements? Okay, so first we go to the question of, essentially this, if you have a really nice apartment and the market value is more than $1,000 a month, I'm trying to do the math here, can you just use the housing as compensation for the employee working at your facility? And the answer is no. They are entitled to minimum wage under federal law or state law minimums for working, and you can provide the housing above it, and that would, in many instances, that's a compensable value to them as taxable earnings, the value of the market value of the apartment. It depends, and this is another determination with regard to your folks that live on site or don't live on site. There's a way for you to defer the income impact of a resident manager's apartment on an employee if they are required to live there as part of their employment. If they're required to live there, then you cannot, that money for the value of the apartment would not be a compensable impact to the employee. It's something that's part of their job responsibility. It's not considered a benefit. If they have the choice and they choose to live in the apartment, then of course that's a compensable value, the value of the apartment, but never can it be used to cover minimum wage requirements. Yeah. I sense a lot of sneakiness going on here. So what we're talking about, and it's a fair question. If the value of the apartment is $1,000 a month, and we're only charging them $200 a month, there's $800 of value that they're getting each month for living in the apartment. Can you then ultimately, can their overtime that they're entitled to can be dealt with by the value of the apartment that they're being given over market value wages? And the answer is no. If they're non-exempt employees, they're actually entitled to the compensation for the hours worked. The fact that you only charge $200 for the apartment when you could charge $800 for the apartment is a decision of the employer. I mean, you would be it'd be very dangerous for you to take any of your apartment value and try to play with the overtime entitlement that your non-exempt employee has. And one of the problems, I will tell you, and I hear this a lot, is because you provide an apartment and other benefits to your employees, the argument is, well, that covers their overtime. It takes care of my employee. I'm doing what I need to do for my employee. The problem is the Department of Labor doesn't care. The Department of Labor believes that employee is entitled to be paid for the hours worked based upon the minimum wage requirements of your state. Yeah. No, the value of the apartment can be separately calculated as an income value, but the apartment itself is not. The value of the apartment is not used to determine a revaluation of the straight time wage. No, they don't have to. That can be separate. Their minimum wage requirements are separate from housing and food and whatever else you may provide. Yeah.
So in California, as an exempt employee, you have to pay double minimum wage. Is that correct or incorrect?
No, that's incorrect. As an exempt employee, as long as they meet the salary test and the duties test to be exempt, then there is no overtime calculation or even that what you're identifying as some sort of odd calculation to make sure that meets the exemption.
Interesting. 2007, we were sued by an employee. They were living on site, apartment included, and utilities and such. And we didn't know, she left us one day and we got a letter from her attorney saying that she was suing us for overtime. At the time, the minimum wage in California was $8 an hour. And we didn't obviously know this well. We were paying her $15.75 an hour. So we were 25 cents off on this double the minimum wage. And so we obviously hired an attorney and went through the process. And the attorney said that the law stated that if she was going to be an exempt employee, and there's the criteria, 2 employees they have to manage, how much, all this calculation, that she would have been legitimately an exempt employee. But since we didn't have that, she didn't have a time card. She came back at us with hundreds and hundreds of hours of overtime, which are double, triple penalty type offenses. So by the time we got down to it, he said the federal law actually recognized the housing as some sort of compensation, but the state of California did not recognize it. That's what our attorney.
Well, it's certainly compensation. The issue is the value of the apartment is compensation for taxable purposes. It's not a substitution for paying someone the minimum wage requirements plus overtime that they're entitled to under the law. I mean, whatever it is, if they choose to live there at their option, that's a taxable consequence. The IRS, in terms of determining the value, would potentially want to know what the value of the apartment is as a taxable consequence to your employee, if it's their option. If it's a requirement, which is most of you who have resident manager apartments argue that it's expected for them to live there as part of their hiring, and therefore that taxable consequence of the apartment goes away. And the problem you're facing, again, is, and I hate to use you as the poster child for this whole discussion, is the fact that you thought you were paying them well above minimum wage in your state, and it turns out that they're non-exempt employees and are entitled to all these other entitlements under the Department of Labor laws with respect to what they're entitled to be paid. So it's very tricky out there. I will give you one sense of guidance. The Self-Storage Association, I know, is one of their publications online, gives a wage and hour guidebook, so you can do that. Certainly look at your own state laws with regard to minimum wage and the salary test to make sure you're meeting your requirements, and happy to answer any questions after the fact. I'll be outside. Thank you all very much for coming this morning.